Welcome to The Docket. I'm your host, Corey Snow. This is episode 15. In August 2023, Mark Meadows, the former chief of staff of Donald Trump, was charged in Fulton County, Georgia, with violating the Georgia RICO Act, along with 18 co-defendants, including Donald Trump himself. Meadows filed a case to have his trial removed from state jurisdiction and handled in federal court, where he likely intends to claim that he has immunity from the charges based on the Supremacy Clause of the Constitution. The requirements to be removed from state court to federal court includes, among other things, showing that the acts charged were committed under color of the defendant's duties in the federal government. The origin of the removal statute goes back to the early 19th century, where it was originally intended to keep unpopular tariff collectors from being prosecuted in state courts. After a hearing was held to discuss Meadows' arguments, the judge the next day asked for further clarification in the matter. Specifically, that if he found that one or more of the overt acts supporting the charge listed in the indictment were committed under color of his office, but not all of them were, would that be sufficient to warrant removal to federal court? He asked both parties to submit briefings answering that question. On August 31, 2023, District Attorney Fani Willis filed a response detailing the state of Georgia's arguments against removal. What follows is an audio narration of that briefing. Please note that to improve listenability, most citations are omitted. Those that are not have been simplified to stating only the name and year of the case. The original document, including all citations and footnotes, is available at a link provided in the show notes. If you are so inclined, please consider supporting my Patreon at patreon.com/docketpod, which allows me more ability to pay PACER and other court fees to obtain documents for me to narrate that you can listen to. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. In the United States District Court for the Northern District of Georgia, Atlanta Division. The State of Georgia v. Mark Randall Meadows. Regarding Notice of Removal of Fulton County Superior Court Indictment Number 23 SC 188947. State of Georgia's Post-Hearing Brief. Following an evidentiary hearing held on August 28, 2023, the court directed the parties to submit additional briefing on a single question. Quote, Count 1 of the indictment, pertaining to Georgia's Racketeer-Influenced and Corrupt Organizations Act, RICO, OCGA 1614-4C, contains a number of overt acts attributed to Mr. Meadows. Would a finding that at least one, but not all, of the overt acts as charged occurred under the color of Meadows' office be sufficient for federal removal of a criminal prosecution under 28 U.S.C. Section 1442A1? End quote. For all of the following reasons, the state of Georgia responds that the answer to this question is no. A finding that at least one, but not all, of the overt acts attributed to the defendant would not be sufficient to authorize removal. 1. The defendant's prosecution commenced not from any individual overt act, but from his entry into a conspiracy. The defendant's prosecution was not commenced against him, quote, for or related to any act, end quote, under color of his office. 28 U.S.C. Section 1442A1. The defendant's prosecution commenced because he knowingly and willfully entered into an agreement to violate the Georgia RICO Act. The overt acts alleged in the indictment, as with any indictment charging a violation of a conspiracy statute containing an overt act requirement, are required to be pled only to, quote, demonstrate the conspiracy was actually at work, end quote. Nordahl v. State, 2019, citing Carlson v. United States, 1951. The defendant is charged in Count 1 with agreeing to join a conspiracy that planned to overturn the lawful results of an election in Georgia. A scenario where at least one, but not all, of the overt acts attributed to the defendant in Count 1 of the indictment occurred under color of office would not be sufficient to authorize removal because it would not demonstrate that his agreement to join in the RICO conspiracy described in Count 1 was an act, quote, for or related to, end quote, his duties as Chief of Staff. An examination of RICO and conspiracy law more generally illustrates the crucial difference between a single overt act and joining a conspiracy. Count 1 charges the defendant with a violation of OCGA 1614-4C in that he, quote, conspired and endeavored to participate in, end quote, an enterprise to violate Georgia statute. Subsection A1 of the statute is violated when a person, quote, together with one or more persons, conspires to violate any of the provisions of subsection A or B of this code section, and any one or more of such persons commits any overt act to effect the object of the conspiracy, end quote. OCGA 1614-4B provides that, quote, it shall be unlawful for any person employed by or associated with any enterprise to conduct or participate in, directly or indirectly, such enterprise through a pattern of racketeering activity, end quote. The question posed by this court contemplates a finding that the defendant has committed at least one overt act under Count 1 outside the color of his office. This would be more than what is required to demonstrate the defendant's participation in the RICO conspiracy. In contrast to a substantive violation of OCGA 1614-4B, a conspiracy to violate that provision does not, as the language of subsection C1 makes clear, require that a defendant commit or agree to commit two acts of racketeering activity himself. Fales v. Columbus Bank and Trust Company, 2004, citing Salinas v. United States, 1997. Under Georgia law, a person is guilty of a RICO conspiracy, quote, if they knowingly and willfully join a conspiracy, which itself contains a common plan or purpose to commit two or more predicate acts, end quote. Cotman v. State, 2017, emphasis added. While Georgia RICO, unlike federal RICO, requires that one of the conspirators commit an overt act, there is no requirement that the defendant himself commit an overt act because, quote, each actor in a conspiracy is responsible for the overt actions undertaken by all the other co-conspirators in furtherance of the conspiracy, end quote. Pasha v. State, 2005, citing Causey v. State, 1980. Accord Akintoy v. State, 2017, applying general conspiracy law to RICO, quote, it is well settled that when individuals associate themselves in an unlawful enterprise, any act done in pursuance of the conspiracy by one or more of the conspirators is in legal contemplation the act of all, end quote. This is consistent with federal conspiracy law. Bannon v. United States, 1895, rejecting proposed requirement that the government alleged defendant personally commit an overt act. Because, quote, a conspiracy is a partnership in crime, end quote, Pinkerton v. United States, 1946, the gravamen of a RICO conspiracy is, quote, premised not upon the commission of the predicates of racketeering, or even an agreement to commit predicate acts, but upon an agreement to participate in the affairs of the criminal enterprise through a pattern of racketeering activity, end quote. De La Osa v. State, 2015, citing inter alia Salinas. The indictment alleges that the defendant conspired to violate the Georgia RICO statute, and the state of Georgia has submitted evidence substantiating that allegation. The defendant coordinated and actively participated in a phone call between co-defendant Donald J. Trump, lawyers for Mr. Trump's presidential campaign, and officials from the Georgia Secretary of State's office, during which Mr. Trump berated the secretary to overturn the results of an election Mr. Trump had lost. On the call, the defendant used the inclusive pronoun we to refer to information possessed by the campaign and its lawyers, and he directly disputed the secretary's investigatory findings regarding the number of dead voters, insisting, quote, "I can promise you there are more than that," end quote. Earlier, the defendant contacted another Secretary of State official and inquired whether the Trump campaign could speed up a signature audit by providing funding directly to the state. And after insisting that he did not play any role in the coordination of slates of fake electors throughout several states, the defendant was forced to acknowledge under cross-examination that he had in fact given direction to a campaign official in this regard. Specifically, the defendant wrote an email, State's Exhibit 1, in which he said, quote, "We just need to have someone coordinating the electors for the states," end quote, and attached a memorandum written by co-defendant Kenneth Chesebro recommending the organization of slates of presidential electors to meet and cast votes for Mr. Trump in states Mr. Trump had lost. Footnote 3. The court has ample basis not to credit some or all of the defendant's testimony from the evidentiary hearing. In addition to the contradiction highlighted above, the defendant said repeatedly that he misused the pronoun we, an assertion that would materially alter the plain meaning of several of his relevant statements. The defendant also repeatedly insisted he was merely, quote, "trying to land the plane," end quote, and achieve, quote, "a peaceful transition of power," end quote, a statement clearly belied by his participation in the Trump campaign's attempts to overturn the outcome of Georgia's election. End footnote 3. The defendant has not disputed his participation in these events. He simply argues that all of them were within the scope of his duties and occurred under color of office. The court, thus, has undisputed evidence of the defendant committing the act at issue in Count 1, conspiring to violate Georgia's RICO statute by joining in a common plan to overturn the results of Georgia's 2020 presidential election. A finding that some of the overt acts attributed to the defendant occurred under color of office would not suffice to show that the defendant's joining in the conspiracy was itself under color of office or even related to it. A case familiar to this court provides a useful example of a scenario where a federal officer's entry into a conspiracy could occur under color of office. In Baucom v. Martin, a local prosecutor was considering filing charges against an FBI agent for the agent's activities related to an attempt to bribe a local official. The attempted bribe was part of a joint federal-state investigation into local government corruption and possible federal RICO violations. The 11th Circuit held that any attempt to secure a bribe fell within the agent's duties as a federal officer conducting such an investigation, and the prosecution was therefore barred by Supremacy Clause immunity. Ibid. If the agent and others had been charged with conspiracy for their coordinated plan seeking to bribe a local official, the case would have been subject to removal because the act of conspiring in that case would clearly have been committed under color of the agent's office. The circumstances of this case are easily distinguishable. The defendant conspired not for any purpose related to his duties as chief of staff, but to transform Mr. Trump from a losing political candidate into a winning one, no matter what the outcome of the election had actually been. The conspiracy did not involve a common plan seeking to fulfill a federal objective or enforce federal law. It sought to fulfill an openly personal goal of Mr. Trump's that the defendant acknowledged he shared. A finding that, as part of that conspiracy, the defendant may have committed one or even several acts that fell within the color of his office would not demonstrate that he was being prosecuted for an act for or related to his office. That is because the gravamen of the charge, the relevant act as contemplated by Section 1442A1, remains conspiring itself, and there is no evidence before the court demonstrating that the conspiracy in which the defendant participated sought to further some authorized or lawful federal interest related to the defendant's office. As a result, the answer to the court's question is no. A finding that some but not all of the defendant's overt acts were committed under color of his office would not suffice to authorize removal of his case. Footnote 4. A single reference in Mesa v. California stating that, regarding the presence of a federal question, quote, if there be a single such ingredient in the mass, it is sufficient. That element is decisive upon the subject of jurisdiction, end quote, provides no support for a contrary result. That statement related to the requirement that a defendant assert a federal defense, and it does not reduce the defendant's burden in making the necessary showing. Quote, it must appear that the prosecution of him for whatever offense has arisen out of the acts done by him under color of federal authority and in enforcement of federal law. And he must, by direct averment, exclude the possibility that it was based on acts or conduct of his not justified by his federal duty. Mesa, citing Maryland v. Soper, emphasis added. Here, in the question posed by this court, the defendant has not made a showing, excluding the possibility, that his prosecution is based on acts or conduct of his not justified by his federal duty. End footnote 4. 2. The defendant cannot demonstrate that he has a colorable federal defense. In the scenario outlined in this court's question, the defendant would not be able to raise a colorable federal defense. Such a defense is required in order to secure removal. Mesa v. California, 1989. In the context of removal, colorable means plausible. Magnin v. Teledyne Continental Motors, 1996. The defendant has attempted to raise a defense of supremacy clause immunity, which requires him to show both that he was performing, quote, an act which he was authorized to do by the law of the United States, end quote, and that, in performing that authorized act, quote, he did no more than what was necessary and proper for him to do, end quote. In regarding Nagel, 1890, emphasis added. In the 11th Circuit, a defendant's claim of supremacy clause immunity is negated by any evidence that they acted out of, quote, personal interest, malice, actual criminal intent, or for any other reason than to do their duty as they saw it, end quote. Baucom. A finding that some, but not all, overt acts occurred under color of office would not suffice to authorize removal of a conspiracy to violate Georgia's RICO statute. By contrast, a finding that some of the defendant's overt acts did not occur under color of office would affirmatively defeat his attempt at removal because it would make it impossible for the defendant to plausibly raise a complete defense of supremacy clause immunity to count 1. As noted above, the question posed by this court contemplates a finding that the defendant has committed at least one overt act under count 1 outside the color of his office, which is more than what is required to convict the defendant under count 1. This is because the state of Georgia need not prove that the defendant himself committed an overt act in furtherance of the conspiracy, but only that someone had committed such an overt act. That person could be any other co-conspirator. However, in the question posed by the court here, where one or more of the overt acts fall outside the defendant's color of office, the state of Georgia's case would be much stronger than that. The person who committed an overt act would be the defendant. This would put the required showing under Nagel that he, quote, did no more than what was necessary and proper for him to do, end quote, out of reach. any Supremacy Clause immunity defense premised upon the argument that some, but not all, of the defendant's overt acts fell within the color of his office would be incomplete and insufficient because a defense applicable only to individual overt acts does not function as a defense to a violation of OCGA 1614-4C. Given the weight of authority contrary to the defendant's position, he will likely emphasize the permissive standards related to raising a colorable federal defense. However, while the defendant need not show a clearly sustainable defense at this stage, he cannot even show a possibly sustainable defense. Likewise, while he is not required to virtually win his case, he cannot even show that his defense would make it possible for him to win his case. Supremacy Clause immunity could do neither under the scenario contemplated in this court's question. To hold that a plausible defense need not be a complete defense would reduce the test for federal removal from permissive to nearly invisible. Indeed, many federal courts have held that a colorable federal defense must be a complete defense, a minimum requirement so uncontroversial that it does not appear to have ever been challenged. See Hagan v. Benjamin Foster Company, 2010. Quote, "Thus, the court concludes that a defense is colorable for purposes of determining jurisdiction under Section 1442A1 if the defendant asserting it identifies facts which, viewed in the light most favorable to the defendant, would establish a complete defense at trial." End quote. Simply put, quote, Section 1614-4C makes it illegal for any person to conspire to violate Section 1614-4A or B. To violate Section 1614-4C, one must either commit an overt act to effect the object of the endeavor, or conspiracy or a co-conspirator must commit such an overt act. End quote. Doe v. Red Roof Inns, Inc., 2021. To prove that the defendant conspired to violate the RICO statute, the state of Georgia must prove that some co-conspirator committed an overt act. This scenario in the question posed by this court contemplates the defendant himself having committed at least one overt act outside the color of his office. Such a finding would demonstrate that Supremacy Clause immunity could not function as a complete and therefore plausible defense. Thus, if the court finds that any of the defendant's overt acts were not committed under color of his office, the defendant cannot raise a colorable defense of Supremacy Clause immunity. 3. The defendant sees no distinction among his overt acts. The scenario contemplated by the court in its order seeking additional briefing distinguishes among the overt acts allegedly committed by the defendant, suggesting that some may fall under the color of his office while others may not. The state of Georgia again observes that the defendant makes no such distinction in his motion to dismiss. Filed on August 19th, the defendant insists that, quote, all of the alleged conduct as to Mr. Meadows relates to protected political activity that lies in the heartland of the First Amendment, end quote, and, quote, all the substantive allegations in the indictment concern unquestionably political activity and thus, if not covered by Supremacy Clause immunity, the charges would be barred by the First Amendment, end quote. The state of Georgia has already submitted arguments to the court regarding the interaction between the defendant's admission, the prohibitions applicable to him under the Hatch Act, and the scope of his duties as Chief of Staff. However, the state observes that the defendant has characterized the gravamen of his own conduct, all of his conduct, as, quote, unquestionably political activity, end quote. Conclusion. The defendant was indicted not for any individual overt act, but for entering into a conspiracy to violate Georgia's RICO Act. The defendant must raise a colorable federal defense not to some subset of overt acts, but to actual violation of OCGA 1614-4C with which he is charged. Thus, a finding that some, but not all, of the overt acts attributed to the defendant in the indictment occurred under the color of his office would not suffice to authorize removal. Instead, a finding that some, but not all, of the overt acts attributed to the defendant did not occur under color of his office would defeat the defendant's attempts at removal. Such a finding would preclude the defendant from raising a complete supremacy clause immunity defense to count 1, and it would not alter the fact that the defendant had no lawful authority to enter into a conspiracy intended to overturn the results of Georgia's presidential election. Even if the burden on a defendant seeking removal is permissive, it is not non-existent, particularly when his case is a criminal prosecution. Where the evidence before the court and the defendant's own admissions demonstrate that his conduct was not authorized by federal law or, quote, no more than what is necessary and proper, end quote, for the performance of his duties, the defendant cannot meet his burden, and his notice of removal must fail. Respectfully submitted this 31st day of August 2023, Fani T. Willis, District Attorney, Atlanta Judicial Circuit. By, signed, F. McDonald Wakeford, Chief Senior Assistant District Attorney, Atlanta Judicial Circuit, Georgia Bar Number 414898. Address and email address omitted. This concludes this episode of The Docket. I hope you enjoyed this narration. For updates on The Docket, please visit docketpod.com or find us on Threads and Instagram as DocketPod. Please consider subscribing to The Docket and supporting my Patreon at patreon.com/docketpod. Thank you.